for 5 minutes.
Well, thank you very much, Ranking Member, and I apologize that I was tardy. We have a whole bunch of things going on today, but this is very, very important. I wanted to be here, so I want to thank all of you. The Trump administration and Trump are undertaking an out-of-control anti-immigrant agenda that is creating fear and chaos, as you all know. Instead of targeting violent criminals, this administration is using taxpayer dollars to tear families apart and deport hardworking members of our community. I live in San Diego. I represent the border area of San Diego. So, of course, there are a lot of immigrants there, and people are terrified. People are terrified, and as we've heard, because of what the Supreme Court has done now, allowing for racial profiling, people are very scared and also, frankly, humiliated. A lot of people are telling me they're afraid that they're going to be pulled over, and their kids are going to think, well, Dad, Mom, why are we being pulled over? Why are we less? And those are things that really stay with people. I speak Spanish. I actually drive an old truck myself. And when I was younger, I was fixing up the house that we live in. I was trying to teach my daughter Spanish. I certainly could have been picked up. My name is Juan, Juan Vargas. So how do they get away with this? I mean, the court now has said in the shadow docket, but what will the court do when it comes to them in full? Will they change their mind? Who's the attorney? Yes.
Sure. Yeah, I'm happy to answer that. I mean, so, this decision from the Supreme Court, it's not a final decision. Right. It is just specific to roving patrols in Los Angeles, but it does signal where the Supreme Court is headed when it comes to racial profiling and profiling on other factors for immigration enforcement. And really what they're saying is that, yes, ICE can look at how somebody looks or the language they speak or where they work or where they're headed when they decide who they're targeting and which communities they're focusing on for surveillance and arrests. The Fourth Amendment does still apply. That is an important set of rights for immigrants in our communities, but we are concerned, given what we've seen from the Supreme Court, that if this question goes more squarely before it, that they will weigh in favor of this kind of profiling.
Well, as a Latino, I don't feel like that Fourth Amendment protects me too much these days, and it doesn't seem like it protects people that look like me that speak Spanish. I mean, there seems to be a real erosion of that amendment.
I think that's correct. It absolutely is eroding a set of rights around not being targeted based on how somebody looks. But it's still the case that, ICE cannot enter into people's homes or businesses without judicial warrants. There are still legal barriers that they have to abide by, and when they don't, it's our job to file lawsuits and hold them to it.
Since you did bring up the warrants, in San Diego, 8 blocks from my house, there was a pretty celebrated raid of a restaurant, and a whole bunch of people were detained, and 4 people were ultimately detained and removed. It was interesting because then I asked to pull the warrant, and I wanted to see the warrant and the affidavit to understand why everyone was detained. And in Section 62, the warrant said that you could detain all of the employees to find out which ones were not here officially. All of the employees, and of course we had a press conference in front of the court and denounced them, saying, where's your probable cause for an employee there you have no information on? How can you detain them? And they actually changed their mind, and they're not doing it now. So they're not signing these warrants. I mean, I think it's very important to take a look at the actual warrants, because there's no right to go into a restaurant, which this was, and detain all the employees. There's no probable cause on most of the employees there.
Yes, and certainly if this is an administrative warrant, which is a warrant issued by DHS, by the agency, then they don't have a lawful right to enter in the way that you're describing. If it is a judicial warrant and a judge has signed off on probable cause, that is different. But
it was a magistrate. It was a magistrate that signed off on it, but it turns out that she hadn't actually looked at Section 62. Which she, of course, should have, because, again, the court now is not doing that. In fact, ICE is complaining about that because they had no right to do that.
Right, which underscores how important it is that in our communities we're asking to look at these warrants, to look at the justifications, to have press conferences, because this indiscriminate agenda means we're going to see more warrants like that.
My time's about up. I really appreciate all you're doing, and I really apologize, too, of what has happened, to your families. We have those families in San Diego that are suffering desperately, like yours, too, and we're trying everything we can to prevent this. It's a real injustice. It's immorality. It's cruel. It's sinful. It's all the things that you don't want to see in a society. It's horrible. And but I thank you for your courage and your willingness to stand up. There's always a few that do, and thank you so much for that.
During a House
thank
Democrats hearing on Thursday, Representative Juan Vargas, Democrat, California, pressed attorney Nayna Gupta about a recent Supreme Court ruling that allowed immigration enforcement officers to rely on apparent race and other factors when deciding whom to stop. The exchange highlighted growing concern that constitutional protections are being eroded under the Trump administration's aggressive immigration agenda. Vargas, who represents a border district in San Diego, opened by describing the fear that has taken root in his community. He noted that instead of focusing resources on violent criminals, the administration has directed taxpayer dollars towards separating families and deporting working people who contribute to their neighborhoods. He said parents worry about being pulled over in front of their children, who then question why their family is treated as less than others. For Vargas, these are not abstract concerns but lived experiences, given his own Latino background and Spanish-speaking household. Gupta explained that the Supreme Court's decision, though issued on the so-called shadow docket and limited to roving patrols in Los Angeles, revealed where the justices may be heading on the broader issue of racial profiling. The ruling suggests that immigration enforcement can consider how someone looks, the language they speak, where they work, or even where they are traveling when deciding whether to stop and investigate them. She cautioned that while the Fourth Amendment technically still applies, its practical force is weakening as courts appear more willing to accept profiling. Vargas responded bluntly that he no longer feels the Fourth Amendment shields him. As a Latino man, he said he understands the fear and humiliation expressed by constituents who now live under constant threat of being singled out. He argued that the amendment's protection against unreasonable searches and seizures means little if it cannot prevent discrimination based on ethnicity or language. The discussion turned to the use of warrants in immigration raids. Gupta emphasized that ICE cannot legally enter homes or businesses without judicial warrants signed by a judge. Administrative warrants issued by DHS do not provide lawful authority for such intrusions. Yet Vargas shared a troubling example from his own district, a well-publicized raid on a restaurant near his home in San Diego. During that operation, all employees were detained under a warrant. When Vargas obtained and reviewed the document, he discovered a section authorizing the detention of every employee, regardless of probable cause. He said this blanket approach violated the very idea of individualized suspicion. After a press conference and public scrutiny, ICE backed down from using such broad warrants. Vargas noted that the magistrate who signed it apparently had not fully examined the section allowing indiscriminate detention. Gupta agreed, stressing that close examination of warrants is essential to hold enforcement agencies accountable. Without pushback from elected officials, lawyers, and community members, she warned, ICE will continue to stretch its authority in ways that harm entire communities. As the hearing drew to a close, Vargas expressed solidarity with immigrant families living under constant fear. He called the administration's approach immoral, unjust, and cruel. Using words like sinful, he condemned practices that leave children traumatized, families torn apart, and communities destabilized. He thanked those willing to come forward and share their stories, recognizing the courage it takes to stand up against policies that carry such heavy personal costs. The hearing underscored how the debate over immigration enforcement is no longer only about border policy but also about constitutional rights, racial justice, and the balance of power between the courts and federal agencies. Vargas's exchange with Gupta highlighted the stakes. Whether the United States will uphold legal protections against discrimination or permit enforcement agencies to rely on race, language, and appearance as the basis for targeting entire groups of people.